Part 5, demand for dismissal. Further, you withheld crucial evidence, and that evidence being the conditional acceptance each and every one of the accused was served and signed for, was given time to correct their criminal behavior. Mine is about child support. Look, you got time to straighten this out. Go ahead and do this, and we don't have to go any farther than this, me mailing you this thing. They chose not to. They chose to acquiesce to the contract. Every one of them did. Every one of these contracts that we put out, no one ever responded back. Say, hey, I'm sorry I did you wrong, screwed you around on your child support all those years and took money from you and made money from your trust and blah, 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 which actually took the money out of the children's. Every time you send a child support payment, the state is creating a duplicate of that charge and taking that money from your trust. You pay $500 a week in child support. The state is making $2,000 off of you every month. Then they get 66% of whatever they can collect from the federal government. Child support is the biggest money-making racket in any state. It's not your taxes paying for shit. It's the money that they're making on you all, including prisons. Man, they're making a shit ton of money on prisons. Look, if prison population wasn't a value to them, Core Civic wouldn't be one of the best investments you could make. You want to buy stock and make money? Invest in Core Civic. They're making money, folks. Don't shit yourself. It's not your taxpayers paying for those inmates. They're paying for it. The inmates their trusts are actually paying to keep them up. Kind of like in the military. If you're in the military, taxes aren't paying for your pay. Your trust is. They're paying you out of your very own trust. It sickens me. It really does. But let's get paid too. If the state and the corporate United States can make money, why shouldn't you be able to? Bust that trust up. By your own argument, in your opinion, you are guilty of forgery. You have falsified many of your facts. You have fraudulently declared that I or we filed arguments in this Tennessee Supreme Court. We never did. We're still challenging the jurisdiction. There, Mr. Guy who thinks we've already given into the jurisdiction. For example, agree that the relevant statutes, definitions of forgery, is to make false entries into a book of record. When I filed nothing, granting jurisdiction under your Yellow Fringe Admiralty Maritime Jurisdiction, where you serve a pagan goddess, Justitia, your JAG officer attorneys played into the corporate scheme by fraud under identity theft, manipulating me and us in the Social Security Sesticate Trust, RJL, CAH, into a court-martial, Star Chamber, Admiralty Maritime Jurisdiction arena, and authority as a PGC commodity for your business empire, which by definition is human trafficking. They're every prisoner is being human trafficked by definition. Look it up. Even though it would have been a criminal fraud to do so, you did not have the military grand jury fix an apparent fair market value to the UCC1s, deceitfully changing them from non-negotiable notices to negotiable lien, fraudulently titled finance statement. This is evidence the prosecutor Mark A. Irwin et al. Tampered with material grand jury and court-martial jury, and tampered with evidence presented to the military grand jury and court-martial. Furthermore, since alleged ignorance of the law is no excuse, the people of the military grand jury and the people of the court-martial jury are required to know a value would have to be fixed to the UCC ones before one could even propose they were or are liens. Hence, the people of both the military grand jury and the court-martial grand jury are guilty of fraud and numerous other crimes against me or us. Bivvens et al., in their opinion, page 18, paragraph 3, qualified that language similar to the following is on the UCC-1. The financing statement covers the following collateral, and I've read this to y'all before, that with the claim a lien number and the common law contract number and the date and how much and the different forms of payment. Bivvens then wrote, although the language used is somewhat garbled. Out of all that stuff that I read, where's the garbled language? Okay, that's what he's saying. This guy is saying, after reading the collateral in the UCC-1, the box 5 or 12, I think it is. After reading that one claim a lien number and common law and all that, I will receive without prejudice. What do you mean? What's garbled about this? However, he did not specify which words he does not understand, or in other words, distorted so as to be unintelligible. Bivvens does go on to convey the collateral descriptions were clearly intended to convey, at least obliquely, an impression that the victim owed the defendant underlying debt in the millions of dollars. First he says this is garbled, and then he says the collateral descriptions were clearly intended to convey. I don't condemn Bivvens at all, but on their ability and I don't condemn Bivvens at all on their ability in only 13 months to break our code, and it only took an education of 12 years grade school, 4 years university, passing the lawyer SAT, 3 years in law school, took and passed the bar exam from a private business entity creating a monopoly through licensing, an internship, and all the years between them, and now to be able to figure the gist of the language we wrote on the UCC-1. I am thankful that we used keywords like claim of lien, common law contract, $12 million and no cents, and such to help him navigate the minefield of confusion you all must have experienced, gaining an insight into the meaning of the garbled, oblique collateral description we clearly intended to convey. The example supports that if such an education and claiming title on the United States or the Tennessee Supreme Tribunal of Justices, that the rest of us ignorance of the law is very much an excuse. Hence, we are ignorant of any law that permits you all to take a UCC-1 financing statement, a non-negotiable instrument, instruct a military jury to place a value on it against someone who is not in the military or militia, and by fixing a value, in order to fraudulently make the financing statement a negotiable instrument and redefining it as a lien in order to prosecute the human, all the while having used identity theft to place your JAG officers to speak for us against our will, is not only an open action of treason, among other crimes. I do not know what would be. According to Bivvens et al. Opinion, the corporate state of Tennessee now has the ability to increase their net worth by claiming that all UCC1s have value. Then through your fraudulent acts, they can then borrow against said net worth increase to the detriment of all the people of the state. Further, you have expanded upon the legislative intent of the forgery statute in violation of the Tennessee-Constitution, Article 2, Section 2, by your opinion, stating that any false entry into a book or record of both the public and private record is a violation of Tennessee Code 3914-114B1B. And therein all acts of fraud in any tribunal in this state can now be charged with forgery. For example, if someone gives false testimony in a trial, they can be charged with not only perjury, but now forgery as well. I do not believe the legislator meant for you to expand upon their authority, which constitutes a violation of Tennessee-Constitution, Article 2, Section 2, which states, no person or persons belonging to one of these departments shall exercise any of the power properly belonging to either of the other, except in the case herein directed or permitted. However, you have now opened the door for charges against you all, have you not? Deciphering your opinion, one recognizes the well thoughts of all well-planned Malthic stratagem that the JAG officers, administrative officer Cheryl Blackburn, and her kaleidocrat circle, including the clerk of the tribunal and prosecutor acting as co-administrator of the court-martial Star Chamber Admiralty Maritime Tribunal, and her fraudulently assigned JAG officers, defense attorneys, that through identity theft assumed authority to act for us. One can discern the depth of this evil my eyes are blurry, getting blurry. Malignancy under the guise of your pagan goddess Justitia. A lien is a negotiable instrument, and a notice of lien is a non-negotiable instrument that perfects the lien. That's what they are. Cheryl eventually understood this reality when we were all forced into the court-martial Star Chamber Admiralty Maritime Tribunal. We identified ourselves to the effect of without prejudice. I am Ronald-James Lyons. In this instance, sovereign and beneficiary. I am here under fraud ministeress Cheryl Blackburn, and you, Cheryl, are a fiduciary. No one objected or denied to my or our reservations of right, identities, conditions of bondage, or Cheryl's status. No one objected to what it was we were saying, including herself. Furthermore, both flags being behind Cheryl, American flag with an eagle on its post, an Army battle flag, and the Tennessee-state militia flag. If there's a gold fringe around your state flag in the courtroom, it's a militia flag. It's their Tennessee National Guard flag. You're in a court-martial, folks. As a yellow fringe borders, and we identified said flags as military flags with no denial from Cheryl et al. Every action of Cheryl's et al. Beyond that was hereby fruit from a poisonous tree. A lot of y'all know that, so I'm not going to read the definition. Cheryl then assigned JAG officer defense attorneys to each of us despite our objection, solidifying the character of the arena and the jurisdiction we had been forced into. And that we were PGC kidnapped by military officer cops, each have a yellow fringe U.S. flag on their sleeve, their uniforms in the tribunal displaying said yellow flags as its jurisdiction. Every cop you all see out here on the road, look, they got yellow fringe flags patches on their shoulders, every one of them. Security guards, TSA, even if you look at the uniforms from the various veterans organizations like the DAV, they're all wearing military flags. We have a gold fringe flag in our chapter. And having been going there for many years, I do stand when they pledge allegiance. I don't salute, and nor do I say it. I stand in reverence for my fellow service members who's died under the color of that flag. So be pissed if I don't say Pledge of Allegiance. That's senseless. Once you make a pledge, you don't have to pledge again. However, we could not have been lawfully arraigned or held prisoner because the alleged military grand jury indictment did not establish that I or we were actively in the military or the militia, or did it establish the UCC-1 financing statement as being a negotiable instrument, thus proving no liens had been filed in Tennessee. Also, with us having not pledged or not pled into any jurisdiction, the jurisdiction was lawfully challenged at that time. We never contracted with the tribunal. We were then held in a cell during all hearings after the ones where the flags were removed, but the flags were brought back in again at our unlawful sequestration and offer from the JAG officer defense attorneys from Sherrill to ask if we wanted to come in. A general statement out loud was said, "We will not be part of your unlawful court-martial." And the JAG defense attorneys said, okay. Thus, they concurred that the trial was, in fact, a court-martial. We said, we're not taking any part in your unlawful court-martial. And they said, okay. They didn't say, wait a minute, it's not a military court-martial. Try that. Thus, they concurred that the trial was, in fact, a court-martial. Other than that, we only spoke to each other and not directly to them professionally, Annette. The case for fear of oral contracting. We never talked to these lawyers. I've stated this before. If Gary's usurping JAG defense attorney said anything to him, one of us would respond to them if we wanted to. None of us ever directly responded to our alleged bogus defense attorney. Even though as beneficiaries we cannot be held liable. You've heard me say that already. Yet they went back into their tribunal and told Sherrill that we told the JAG officers, defense attorneys, that we would not come in, fraudulently indicating that for the record that we had contracted, yet in truth we had not. This falsifying of the record, by your opinion, is thereby a forgery. It's a forgery. According to the Chief Justice's buddy there, Bivvens, Sherrill continued with this unlawful proceeding without a contract or jurisdiction by conspiring with her cohorts to fully engage in the identity theft of each of us, devising and acting upon her future fraudulent negotiable liens by securing permission from her co-conspirators, minions, to have the military jury fix a value to each UCC-1 at the end of the trial. Moreover, the actual claim of lien instruments were executed before the UCC1s supported by Bivvens et al., wherein Bivvens et al. On page 18 of their opinion clearly has written from the UCC1 financing statement that it covers the following collateral. What I'm talking about, what I've already read before, so I'm going to save a little time. And then the ability to place a lien upon a man's property. That's United States Supreme Court, 1969, Snydash versus Family First Corporation. Let me do this so y'all can look it up. 395 U.S. 337 and 349. It is written indicating that the claim of lien was created before the UCC1, meaning it was a perfection of the lien document. When Cheryl et al. Ordered a value placed on each of the UCC1s, she designated them as liens so that she could qualify them as a fraudulent lien because each UCC1 is in actuality not a lien but a financing statement, a perfection of a lien, and notice of lien for the world. Hence, a fraud order after Cheryl et al. Manipulated through Cheryl being the fiduciary, making Cheryl the guilty party of filing fraudulent liens in Davidson County government, and also a forgery. She's the one that filed in Davidson County. These facts were obviously obvious from Bivvens et al. Opinion. However, being a member of the Monopoly Titled Bar Association, misdirected in Bivvens et al. Is a quintessential path to cover up Cheryl et al.'s treason. Furthermore, as the conditional acceptance supports each party received the claim of lien, the conditional acceptance is the underlying security agreement, and it's also a claim of lien. You don't need to do like I said, you don't need to use UCC 1s and 3s because the conditional acceptance is a claim of lien. It says it in it that we filed with the United States Treasury, and nothing was ever filed in Davidson County, Tennessee government by me or us. The plaintiff JAG attorney then began further identity theft in an attempt to gain jurisdiction and falsify further the record by presenting their argument in such a way as to appear other points were concealed when, in fact, we the people concealed nothing. The conspiracy that began with Mark A. Irwin, he's the TBI agent, who sat at the trial as the prosecution. He's an agent. They made him the prosecutor, and the district attorney's office assigned prosecutors to do it. If you're a cop, if you're out here and you're a cop, and you write someone a ticket, you got to show up in court because you're the prosecutor. If the cop doesn't show up, it's like the prosecutor never showed up. That's why this Mark A. Irwin guy, a TBI agent who had investigated, that he was actually the prosecutor. That's why we mention him a lot. The conspiracy that began with Mark A. Irwin and Cheryl et al. Had accomplished its goal to treasonously extirpate all sovereignty and every right of action to recourse into the socialistic I get tongue-tied sometimes, kaleidocracy, where all is licensed through the public officials. Treason by any other name is still treason. I'm going to make one more about this is the conclusions and what it is we're demanding.